So as you can see, there's no way we're gonna get to all these bills this morning. This is sort of a working list. Some of them are ready to go and some may need a little more work, but we're gonna hopscotch around this morning, get as much done as we can, and then we'll call obviously additional meetings as needed. So first we're gonna turn to Chairman Wiggins, and he has some guests and a bill that we're gonna call up and look at first, and it's Bill 2231. I think it's about the fourth one down the list. And so we'll turn it over to Senator Wiggins. You can introduce your guest and present the bill and take questions and all that good stuff.
Thank you, Mr. Chairman, for this. It is 2231, and it's what I'm calling Katie's Law 2.0. And for those, I guess, newer members, about 4 or 5 years ago, we passed Katie's Law, which is and you have in front of you DNA saves. The bottom line is it's DNA that is used. DNA has basically become the gold standard in criminal justice in trials. And Katie's Law is named after Katie, who was murdered in New Mexico. And we have with them J.N. Sepich with DNA Saves, and we also have Ashley Spence. Many of you have met them. What the bill, I'll go to the bill and then mention a few things. The bottom line is the current law in Mississippi is that we collect arrestee on felony crimes. DNA is collected, which goes into the CODIS database, and that solves crime. That goes in with matches, solves crimes, but also exonerates people. And it's been a successful program. 30 other states have it. What this bill is doing is simply making it arrests on DNA collection on all felony arrests. And in the bill, so basically it's taking, extending it to all felony arrests. And I know there's questions about what happens on the bill, on the DNA once it's collected. If you look at lines 22 to 24, and then you look at line 61 to 63, that any DNA collection can be destroyed and is destroyed should there not be a conviction or anything like that. Speaking of DNA, there is absolutely no identifying information in DNA. If you actually read here in the brochure, there are laws, federal laws in place to restrict and protect information, private information. When you collect DNA, there is absolutely no identification of whose it is or what it is. And those are protected by federal law. And so the concern, which is valid, that there may be a release of identifying information or anything is actually non-existent. And so with that, I want to turn it over to J.N. and Ashley. J.N. is from New Mexico, and Ashley is from Austin, Texas. And I know many of you have met them and appreciate if they could address the committee. And they know 5 minutes.
You're recognized.
First of all, thank you, Mr. Chair. Thank you for the video. It's a lot of you know about my daughter's story. What I want to concentrate on is why it's important to see a different what you're doing now, taking a DNA swab and trying to arrest the violent element to all. Why does that matter? Well, it matters because there are states now, 18 states now, all of them. And that keeps your neighbors
Jayanne, to the point about where we were going, I wanted to have Ashley tell her brief story because I think that applies here.
Yes. So that's why it's so. And as Sarah had said, people on the back of my business card, first on the front, this is first my jurisdiction, all laws, and problems. But if you look on the back, it actually is my candidate profile, my actual vote profile. But with the incumbents in my registered government, it has nothing about these 20 markers, about 3 million certificates. There's no genetic information. You can take that to a PhD in genetics. You can take the whole line. You can take what you're supposed to get. You can't take any of that. Once there's no names up back here, I'll get that's the ID number that's matched back to the person's name after there's a match to the form. So there's a lot of privacy protections. And as Sarah had said, it is a federal regulation that the person that is addressing is not convicted for that crime, that they must have their DNA, have their DNA expunge from because of the process. It's not like they're all over the place. It's hard to expend it. And the officer of the inspector general does apply every year in every state to make sure that expungement is taken place. So it's a very well put together system, and I would like to see any questions that you have.
Yeah, I wanted to let Ashley, Ashley Spence is from Austin, Texas, and she is, both of these ladies are victims, and she is here telling her story. I'll just, jump to it, but Ashley is a rape victim, and she was in Austin, and, 7 years later, through DNA, her attacker was identified through I think it certainly was a nonviolent offense. And through that match, he was put on trial, and he's now serving 130 years for sexual assault and rape. Ashley?
Thank you so much. Yes, I was in Arizona State actually. I was 19. I was about to begin my sophomore year of college. And I went to bed one night as I had, thinking I was safe and well. And this night I wasn't, and I had no idea what my mind was. In an instant, I went to bed and I was awoken violently and putting my clothes on. I began to fight with everything I knew. And I knew at that moment I continued to fight. I would covered my face. So in order to try to survive, I endured this for hours throughout the night. I was really great. I am so grateful that I survived physically, but I never saw this man's face. When he called off my body, I was trembling, and I just thought, oh my goodness, I might survive. He told me, do not tell anybody. I will harm you. I will hurt your friends. I was watching you. I will be watching you. But I did. I told all 911. I had forensic exams done. And, eventually the case just, there were no leads. And I was in her like, so I moved to Newport Beach, California, and then eventually relocated back to Austin. It was 7 years later that I was shot. 7 years. What happened was I moved to Newport Beach from Arizona to try to escape these horrible accidents. But I really moved to the very city where he lived. He was from Newport Beach.
Ashley, what did they arrest him on?
They arrested him for resisting an officer. Thank goodness in California they have this law that all felony arrests DNA is taken. So it didn't match back to my case in Arizona 7 years prior to Lewis. And the reason that I'm so passionate about this is because I know had he been arrested in Arizona where my attack was, he would still be able to be operating in Florida.
And was that the only identification for the case?
When they arrested him, they found a shed of women's underwear, driver's licenses from all over the world. It was purely the DNA evidence in this log. I never saw his face. Actually, when I saw him in trial, I didn't recognize him. So I know how powerful this is. And there's also another case here in Mississippi in 2014, a woman who was very brutally raped, thrown across a bridge in Ocean Springs. And her perpetrator was on the loose. It wasn't until recently, through a DNA match in Utah, he was arrested for had he been arrested 5 years.
Mr. Chairman, I will open it up to questions. I would say I appreciate these ladies coming and giving their testimony. This is, and we were talking last night, to take what they've been through and make really something good out of it. And I will say this, that they also have with this group, and forgive me for his name, but the gentleman who was going to be here spent 13 years, 18 and a half years in prison. DNA cleared him, and he is a spokesman for DNA Saves. So not only is this about, this is, as JN has said, this is about truth in the justice system and getting to the, and making our system better. So with that, I'll open it up to any questions.
Any questions, committee members, for Senator Wiggins? Any questions? Yes, Senator Turner Ford.
Thank you, Mr. Chairman. I don't want to be insensitive by asking this question, but
Ask whatever you need.
thank you. What is the proposed funding source for the collection of the samples, and where will they be stored? And my concern specifically is this going to be an expense that will be borne by the counties or?
So when we did Katie's Law the first time, so the crime lab, understand this, this goes to the crime lab. When you do a swab, and that's how it's done, it goes to the crime lab and it's collected and it's analyzed. So that's paid for, in any case, that's paid for by the counties. They have a budget that they do that. When Katie's Law was passed, we worked with the Mississippi Crime Lab to make sure that happened. Then there's also federal grants that come down. Actually, a couple years ago, there was a federal grant to encourage states to adopt Katie's Law because they wanted to give states the opportunity to do it. So working with the crime lab, the funding source comes from federal law, and there is a federal version of Katie's Law. So there's a lot of funding sources that come out from the federal, from the feds and other things. But the actual collection and all that is borne just like any other case, drug case, forensics, whatever that is, by the counties. And in terms of the process, it's already being done in different, so the law's already here on, so if they're arrested, let's just say on an aggravated assault, they're already doing it, they just swab them. So the process, it's not about creating a new process or anything, it's just simply doing that, so it's covered.
So do we have anyone run any numbers in terms of the number of felonies that would be, just, I guess, in previous years, an estimate of how this will impact those county budgets?
I haven't known.
Senator Wiggins, do you know if there have been any matches made from the law we've already passed?
I think their JN probably may know that.
That would be helpful information, yeah. Senator Sutton.
Thank you, Mr. Chairman. And I know we've seen this bill several times, and I've had opportunity to meet with both of you all, and so sorry about what happened to both of you. I know in previous years, one of the concerns was like a Fourth Amendment concern regarding a search and seizure right now. And I know Senator Wiggins indicated that we are doing it in some felonies already. And I guess right now, when we just say all felonies, that is a concern that I have received. And I know the way it happens now, the DA will go to a circuit court judge and actually file a motion to request the DNA sample. And of course, that judge will evaluate that application and make a determination and issue an order to actually extract the sample. And so how, if at all, would that change if this bill becomes law? And also, what are we currently doing now, and what felonies are listed now that our DNA is being collected upon arrest?
So thanks for the question. First of all, the U.S. Supreme Court about 2 or 3 years ago, ruled a version of Katie's Law is constitutional under the Fourth Amendment. It's I think it's the King case. And what this U.S. Supreme Court ruled was that it is the equivalent to basically fingerprints. You're not violating the Fourth Amendment when you do this, when you collect DNA via this law. And so that actually, do you remember the name of that, Jan? Maryland. Well, if we need, so Maryland v. King and the U.S. Supreme Court ruled that. And then in terms of the offenses, the way it was originally written, our 9732, which is the list of our violent offenses, and that's what it applies to. So, and in terms of the search warrants and all, this is like fingerprints. And as many lawyers know, the U.S. Supreme Court has ruled that collecting fingerprints is not a violation of the Fourth Amendment. And there is a little more enhanced protection on I think on blood draws and things like that. But under the Maryland v. King case, they've said that's the equivalent and it's not a violation of the Fourth Amendment.
I recognize, Mr. Chair. All right, thank you. And so, if I'm reading this correctly, this will be more expansive. It actually would apply to all felonies as well as attempted felonies. In fact,
It's a felony arrest. It's arrest.
there's a felony arrest. Okay, so and so so it could be a property crime, whereas right now on property crimes, depending on the type of property crime, the only thing that may be relevant will be fingerprints. But what we'll do now, say grand larceny, somebody actually committed in a Delta at one of my farmers, they steal anhydrous ammonia because they're addicted to crystal meth. I guess upon that arrest, even though it has nothing to do with his or her DNA or blood, or we'll basically be taking his DNA sample even on that type of crime if this bill becomes law, correct?
Yes. If I may explain, yes. And when you're arrested for grand larceny, they take your fingerprints. They do that already. And also for those, I guess to explain it as easily as I can, under the criminal law, in order for there to be an arrest, there has to be probable cause, okay, that has been set out by the U.S. Supreme Court. So you cannot arrest somebody if there's no probable cause. So before they even get to an arrest on somebody that say is a grand larceny, there has to be the investigator, police officer has to have an arrest warrant signed by a judge that the judge has ruled there is probable cause for that. Then that's an arrest. But then you go through the process of going to grand jury for an indictment. Okay. And then if there's a no bill, then under this law, you can get the DNA deleted and destroyed. Then you still have to prove it beyond a reasonable doubt unanimously in the state of Mississippi. If none of that happens, you can destroy the DNA. So as far as the arrest, yes, that happens all the time, and you have to have probable cause. You can't just go out there and do it. But it would be expanding it, yes.
And so would it be a friendly amendment to limit this to what we already have regarding Katie's law by saying we only wanted to apply to all of the 9732 crimes, which are the crimes of violence? Thank you.
Other questions? Senator McConnell.
Thank you, Chairman, and thank you, Chairman. My only question is, last night I believe we talked about the destruction of DNA at a certain time. The way that I read the bill, though, it seems like it's upon a request.
It is the way the language.
Request, or has that got to be a petition with the court? I just want to know how that mechanism actually works.
It says expungement request, and it says petition, so it would have to be with the petition on
They
that.
would actually have to make them open a case to request that destruction.
Well, they would, you know how it works. You would have, I think most everybody would have a defense.
There's a definitive obligation with the court to seek destruction of the DNA.
Yeah, so it would have to be most would have a defense attorney, so I think that would be, it's not a problem.
Bearing expense to do that, right?
Yes,
That's a fair question.
yeah.
All right. Other questions? All right, if not, Senator Wiggins to close.
Title sufficient to pass, Mr. Chairman.
Motion is House Speech to pass. Would you like to speak to it?
I pretty much said it. I think that, the protections, this is a good bill. It's a pro law enforcement bill, but it's also a pro victim bill. But it's also a pro improve our criminal justice system. Many people know the Curtis Flowers case in the state of Mississippi. Dare I say, if DNA was being used from start in that case, Mr. Flowers would not have been in prison for all those years. And this is about making our criminal justice system better. And JM will be the first one to tell you that it's about getting at the truth. And within the criminal justice system, DNA has become the gold standard. The Innocence Project uses DNA all the time to free people. Now, it's a way to make the system better, but it's a way for people like Ashley, who've been through what they've been through, to have their justice. And that's all we can ask is from our system, is that the victims have justice done for them, and it can lead to possibly repeat offenders or certainly serial offenders being taken off the street. So my motion is title sufficient to pass.
All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. Roll call has been requested. All in favor, please raise your hand, and the secretary will take accounts. Very good, secretary. All right, you are. I was looking around. Senator Thompson, you're the secretary. All right, all opposed, raise your hand. I will break the tie. I'm in favor of the bill. So
Thank you, Mr.
the bill
Chairman.
passes 7-0. All right, thank you for your presentation, ladies. Thank you for being here. We're gonna go next, like I said, we're hopscotching around here, to Senator Sparks and Senate Bill number 2587, dealing with commercial driver's license. Senator Sparks, you are recognized. I think there's a committee sub on that one, perhaps.
Thank you, Mr. Chairman. On this one, I do believe we are on the actual,
Okay.
original bill.
That was my mistake. You're recognized.
I have committee subs on others, Mr. Chairman, so I apologize for that.
No problem.
This particular bill deals with those who have a commercial driver's license, but are operating a private vehicle. So to cut to the chase, I have a commercial driver's license, but I'm in my car or my pickup, a private vehicle that a commercial driver's license is not required to operate. If I am charged with a moving violation, being a speeding, stop sign violation, something along those lines, that I would be afforded the same remedies as someone who carried a regular operator license. Often we get to court and the word masking tickets is thrown at us with CDL drivers. While they're in their commercial vehicle, it's a different issue, but I believe that they should be treated the same, and that's what this bill would do. That, as you can see in section 2, a moving violation who is operating who's operating a vehicle does not require the possession of a commercial driver's license shall be treated as if the moving violation were against a person who only holds a regular driver's license. Subsection B also says, and if you've ever looked at a uniform traffic citation, there is a box to check that this violation is pursuant to the commercial driver's license law. Very seldom is that box checked. But just to be honest with you, when you go before our judges, they have been informed at some judicial training that NHTSA says this, that, or the other. First of all, NHTSA is not the state of Mississippi. These are violations that occur within the state of Mississippi. We have a shortage of CDL drivers, and they're getting dinged on moving violations in their private car. Subsection C says this does not apply to DUIs. It does not apply to driving under the influence. While I think the same disadvantage is present, after talking with the stakeholders, we have excluded DUI. So I don't want anybody to think that this is going to apply to a CDL driver in their private vehicle that has a driving under the influence offense. I have spoken with the Trucking Association with this language. I've spoken with the Department of Public Safety. I've spoken with the AG's office to make them aware of this legislation. And I have reached out to Senator Wicker's office, who sits on Commerce, to make him aware of his office of this legislation, so that if there is some feedback from NHTSA, that we're prepared on that. But I believe it's a fair treatment of our CDL drivers in their private vehicles. Now you'll need questions.
Very nice. All right. Any questions for Senator Sparks?
I am not aware of any are, any other states. And it's unfortunate because our justice court judges and our municipal court judges and justice court judges are elected. Municipal court judges are appointed and they have this discretion. Keep in mind, this doesn't mean tickets are dismissed. This doesn't mean you just simply have the right afforded to you what is afforded to a non-commercial driver, which they have been repeatedly told is not, is masking tickets. And if the law says you can do it, I think we overcome that hurdle.
Thank you, Mr. Chairman. Isn't there some question under current law about whether there's an equal protection issue between current law and how things are being handled between CDL drivers and non-CDL drivers?
I agree, Mr. Chairman. I think that without question, you have two people driving a private car and I get stopped for speeding, and yet I can go to court and get some relief that a person who happens to have a commercial driver's license cannot. There's a greater argument to say I don't deserve it because I'm a lawyer and I ought to know better, and I'm a legislator and I ought to know better. But if I go to court, I get treated better than our commercial drivers.
And many of the judges who see this have questioned the equal protection side of this as well because they're seeing it.
Yes, and I've certainly made that argument on several occasions in front of them.
Thank you.
Thank you, Mr. Chairman. In line with Chairman Wiggins' equal protection argument, I know that there's been a bill filed year after year regarding how our commercial driver license drivers, our CDL drivers, are being treated when they are in their personal vehicles regarding DUIs. Isn't that the same argument that we've heard or that we are hearing aside, I guess, from the funding issue and the risk of the funding? Do you agree, Senator Sparks, that that's the same type of argument when a driver who has a CDL license is in his or her personal vehicle and they get pulled over, they are treated differently than you or me who would drive in our personal vehicle who actually is cited for the same type of offense, DUI?
Senator, I agree that it is the same argument in principle. And, you know, the reason we particularly excluded that in this bill, DUI is a lot more complex. Plus, I think the trucking industry would be concerned if they had a driver who had received a DUI in a private vehicle that was still driving for them. And then finally, if you've received a DUI, you can put interlock in your car for a non-adjudication or conviction. You can't run interlock in an 18-wheeler. So it would, I think someone who has a CDL is going to lose that driving job on a DUI charge either way. But while I agree with you that in principle it's the same, in complexity is not.
So what exactly, so would this allow a person with a commercial driver license to get a ticket and bring the
Sure, I would make the argument that we see a multitude of resolutions of cases, often cases that are dismissed with cost. That could be court cost, it could be payment of the fine, it could be amendment to a non-moving violation. All those things have been afforded individuals who do not have a commercial driver's license. And as it relates to driving school, we do have to look to federal law that we have adopted. I think that by statute is not made available. So if it conflicts another law, I think that's going to be a problem. But I think the resolution is something that can be handled at the local court districts as long as they know that state law says that we give you that authority.
Other questions? Senator Sparks?
Title sufficient. Do pass, Mr. Chairman.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you. Thank you. All right, we're going to come back over to a couple bills that our esteemed committee council is going to present for us. The first one, Senate Bill 2397, dealing with controlled substances authorized for automatic defense for charges brought within 2 years of a federal declassification. I don't think that's really worth the meeting.
Thank you, Mr. Chairman. This bill is a attempt to administratively schedule a controlled substance on the state schedules. And what the language does is it allows the state health officer to administratively schedule any controlled substance that will allow a controlled substance that is scheduled federally outside of a legislative session to be prescribed and available to people in Mississippi. In 1974, there was a Supreme Court case that struck down a similar provision, but it dealt with criminal notice to people. And this language specifically states that this scheduling is for administrative purposes only and has nothing to do with criminal liability. So the prosecutors or anyone won't be able to charge under this language until the legislature reconvenes and decides if they're going to schedule federally the substance. And administrative scheduling under the language there on lines 22 and 23 it's for a period of 2 years. So if the legislature decides in the interim in those sessions not to schedule, the administrative scheduling is only good for 2 years. But that allows the pharmaceutical companies to go ahead and prescribe and package under the state law.
Thank you, Mr. Chairman. I just have a very friendly amendment to offer here. I'll just explain really quickly. On line 14, I believe 2A should be 1A. Aye. This should be passed committee soon. All in favor, say aye.
Aye.
Yes, that's the reason that people work on that one. Thank you. All right. Next one is Senate Bill 2263, bill of adult adoption, authorizing chancellor to waive procedural requirements. You're recognized to explain that one.
Thank you, Mr. Chairman. This bill 2263, the operative language is in subsection 10, and it states for adult adoptees who consent to the adoption, a chancellor may waive any of the petition requirements and procedural requirements within a certain number of subsections within this section, subsection 4, 6, 7, and 8, and those deal with home studies for minor children and any concerns that the chancellor has under various acts that deal with human trafficking and other matters, obviously not concerns for adult adoptees who actually sign on to the petition for adoption. Senator Bryan.
Yeah, so I didn't have to come, but he's not here. So any questions about this bill? We will try to build it, but I think he had a situation up in his part of the world, up in the Avery area, but where an adult wanted to be adopted. They got to go through all these hoops and hurdles that they thought were dealing with the fact that you're not dealing with a minor child, but rather an adult that wanted to be adopted. So we got the bill. So that's the bill. Any questions? Heard the motion. All in favor, say aye.
Aye.
Opposed, nay. The ayes have it. Senator Simmons, would you handle that one for us on the floor? You want to give it to Senator Ryan? You may have some good stories to share about those. All right. Let's now move to. All right, we're going to recognize Vice Chair Senator England on Senate Bill 2073. First one, your bucket.
Thank you, Mr. Chairman. So this bill is one that my DA approached me about a couple of years ago. What it does, it allows an enhancement to the crime for fleeing or eluding a police officer. We presented it in this committee a few years ago, but you'll see this just increases in an event that an adult is fleeing or eluding an officer and has a child that's 15 years of age or younger. This allows the enhancement to take place, so they can enhance the penalty and make it a heavier penalty for drivers that do that. When we discussed this before, we had some very good questions about whether someone is deemed to be fleeing or eluding when they're actually just looking for a safe place to pull over. well lit, or an easy place to pull over. So we added, if you'll see on line 57, added a defense that I believe takes care of that concern. I think it was a very good concern. And you'll see it says if the driver proceeded in a safe manner to a reasonably near section of roadway more suitable for stopping, a reasonably near side road, or a reasonably near area designated for public parking before stopping. So we did add that as a defense, I think, to take care of those concerns. But very simply, that's what the bill does. Oh, and I will say that if you'll notice, for instance, on line 29, it says any person who is guilty. And then again, on line 34, it says any person. Well, the enhancement, I made sure to add it as an adult. I didn't, the purpose of this bill is not to get at 2 16-year-olds fleeing. It's strictly for adults that have a young child or a minor in the vehicle that's putting that minor in danger. So that is the bill, and I'd be happy to entertain any questions.
Thank you, Mr. Chairman. Thank you, Senator England. Do we define, and maybe we already do this in the code, but do we define what age is an adult?
Well, it's my understanding that an adult, according to this code, and I can refer this over to council, would be the age of 21.
Okay, as long as that's clear, I think that, we could obviously say a person 21 years or older who violates this. Second question, because I think this is a major change the way it was presented the first time. 97-972 subsection 1 is a misdemeanor offense, correct? In other words, the current law.
Yes.
Subsection 1 is a misdemeanor. And the original version of the bill had a felony enhancement to a misdemeanor. Do I understand that subsection 5, which is 39 through 44, makes it an enhancement misdemeanor on the misdemeanor crime, not a felony?
It appears so, yes.
Okay. I just want to make sure that we are not adding a felony enhancement to a misdemeanor crime.
Okay, yeah, I think that's a very good concern, and I believe we do that here.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Lines 45 through 50, isn't that felony language?
Could you tell me the
So,
lines?
sorry, section 6. This is not less than 3 years.
Yes,
no
that
more
would,
than.
so that would be a felony if it is that long, yes.
Okay. And do we know the effect this bill will have on the cost savings that we anticipated generating from House Bill 585? 585? I think 585 in the 2014 regular session. I think the goal was for us to try to generate $300 million over 10 years and reinvest those dollars in corrections. And also if we were going to add any felonies to find out what would be the effect of any new felonies to those goals. Do we know that?
I do not, but I'd be glad to look at that. If we pass through committee today, I'll definitely get back with you on that and work with you to make sure we get that question answered for you.
That's all I have right now, Mr.
I'm sorry to come back for a repeat. The underlying felony crime of felony fleeing has as I understand it, an existing law, has a 5-year maximum, no minimum. The enhancer is not less than 3, not more than 5. That's a mandatory 3-year sentence on the enhancer of a crime that has no minimum. Is that the intent of the bill?
Yes, it is it's to enhance the penalty for doing so when you have a minor in a vehicle.
Okay, with a mandatory minimum.
That's right. That's the way it's written, but I would be happy to entertain any amendment that you have.
Well, I would just find it hard if we have a no minimum 5-year cap on the actual crime, that if somebody's in the car and we have an enhancer that we're adding, that's a second unique felony that has a 5-year penalty. but we're gonna give you 0 time for the underlying offense, but we must give you a mandatory 3 years on the enhancer. I don't know if I know of other situations like that in criminal law, but I would prefer the language be 0 to 5.
Well, I will say this, that so obviously the intent of the bill is to enhance the crime when you have a minor in the vehicle. So I do think that having a minimum of 3 years would be something that our DAs would be in favor of, simply because they've asked for the enhancement. They're having trouble getting this by other means. And obviously, if we have a law like this in place, we are, I guess, deterring people from fleeing and eluding when they do have a minor in the vehicle, putting minors in danger. But I would be glad to work with you with that, Senator Sparks, and talk with you more to see what we can do before this comes up on the floor, so we pass it through committee today.
Thank you, sir.
I think Senator Sparks brought up a good point, but I see it a little bit differently. Maybe the reason why we're needing this enhancement is because under the original felony crime, there's no minimum at all. And maybe that's why we're continuing to see this happen. So I can see with the original law why we definitely need an enhancement with children in the car. So I think that just brought up a point that the original felony, you may not get any time. So if you got a child in the car, you may not get any time unless we do something with it. Is that correct?
That's correct, Senator.
Thank you.
I'm just getting a chance. So basically, all the enhancement is taking away autonomy from the system and the fault that they have to have.
Yeah, so currently the enhancement is not in our statute. So yes, this does add the enhancement and does require the penalty when there's a minor in the vehicle. And again, it's something my DA asked for, particularly because they were seeing instances where they were having minors in the vehicle and they just couldn't find a way to get to get at that issue, that there was a minor in the vehicle that was put in danger by someone fleeing and eluding.
So, just in simple terms, though, the max stays the same, everything stays the same. Once it only adds.
It does do that. Well, I'm sorry. Yeah. So, yeah, it's additional. This does add an enhancement to the current code. So everything that's added is added, but that 3 to 5 does have a minimum to it.
I guess my question is, if there wasn't a child and the difference between having a child and not having a child, the difference in penalty for that you have.
Yes.
Thank you, Mr. Chairman. Enhancements are new crimes. So I guess I'm gonna go back to Senator Sparks' point. You can have a situation where a person is charged with felony fleeing. A judge sentenced that person to 3 years because the statute currently says 0 to 5. But with this enhancement, you add an additional 5 years mandatory time on that 3. And the question is, they have an 8-year sentence. Enhancements are new crimes. So when enhancements are indicted, they are indicted on the same indictment, but there is an underlying felony. The underlying felony could be grand larceny because they just committed a grand larceny. It also can be felony fleeing, count 2. Then also, if this becomes law, you're also going to have the enhancement, which also the judge and the DA and the defendant, along with his or her counsel, will have an opportunity to allow that to go through the process. I guess my concern, Mr. Chairman, is in our current system, wouldn't the facts of every situation determine what the sentence would be under the current statute? So if a child is in the car, my judge in the Delta give a person 5 years. If a child is not in the car, and they may give them 1 year to serve. So I guess my question is it needed under the current law that has a range of 0 to 5, and the facts should play out and determine what the sentence should be, because my DA is going to treat a child being in the car very, very seriously. But the enhancement, Mr. Chairman, I think I'm going back to some of the Sparks point. On our current law, there is not a mandatory minimum, and felony fleeing is subject to all of our rules in MDOC regarding calculations. But then when this enhancement comes, the sentence, will be consecutive to the underlying offense. So how, if at all, would it be calculated by MDOC? That's another concern. So I do have an amendment at the appropriate time.
Let me ask one quick one. Is there a reason that we went, you look in section 5, there 39, you know, we maxed out at a year, and then we jumped from a year maximum to 3 years minimum. But generally in the statute, it usually follows with max being minimum plus end. So I wondered if there was a reason that we jumped for a minimum of 3 or maximum of 4.
Yeah, so if you look back at section 1, which is already in the code, and then section 2, it is a more serious manner in which the fleeing and eluding takes place. So that the enhancement follows, under section 1, if you violated section 1, you've got the up to 1 year. If you violate section 2, which is a more serious instance of fleeing and eluding, then the enhancement jumps as well. So it follows the code as it is.
And I guess generally what I'm looking at is in the rest of the code, generally it's stair steps. Maximum 1 year, and then your next enhanced or your aggravated or whatever it may be a minimum 1 year, maximum 5. So I guess I just wondered if there was a reasoning that we just jumped 2 years from the.
Right. Well, I mean, the reason just being that I felt the minimum was needed when in the instance when a minor was in the vehicle when section 2 is violated. I'm wondering if Senator Simmons' amendment may take care of what we're looking at. But that's the reason. If you look at section 1 and section 2, there is an obvious jump up in the act that led to a bump up in the penalty.
I understand.
Okay.
Thank you, Mr. Chair. My amendment is on line 50 to change 3 years. Well, I guess to say the language, delete 3 years from line 50 and say that the penalty for is not more than 5 years. So the goal of my amendment is to have no minimum, but to say that the enhancement should be 0 to 5 years.
On the amendment. Okay, so the effect of your amendment is to effectively gut what is trying to be done with the bill, because the current penalty is already up to 5 years. So what you're doing is, even if there's a child in there, the judge can sentence them to a minimum of 0 years. Isn't that what your amendment is doing? No, let's if I may understand. So subsection 2, which is current law, any person who's guilty of violating the first one, who operates in a reckless or willful disregard for the safety of the persons who operates a motor vehicle, manifesting extreme indifference to the value of human life, which, by the way, is very similar to DUI, then that is a felony punishable by more than 5 years. So where your amendment is, if you look at line 45, an adult who violates subsection 2. So that language from 45 to 50 is only applying to subsection 2, which is already a felony. And that means that if your amendment would carry, then it's 5 years. You're not doing anything to change subsection 2, which is the purpose of the current language in the bill that's drafted. So the idea, and correct me if I'm wrong, is, Senator England, is the purpose is that if there's a child in the vehicle, that we are increasing the penalty because they know the child's in the vehicle. Is that right?
That is correct.
Okay. So is that not what your amendment is doing, Senator Simmons?
Senator Wiggins, my understanding is gonna be an enhancement. If it's treated as an enhancement, it basically would be a possible 10-year sentence as opposed to just a 5-year sentence. So Senator Sparks, I mean, is that the way?
Mr. Chairman, if I may, that is my concern, is that this is an indictment with 2 felonies with a maximum potential time of 10 years. And if I'm found guilty of both, has a minimum of 3 mandatory because of the second offense. If I'm misunderstanding that, then, certainly would rely on legal.
As the other bill. Are we talking about the second felony? Enhancement, or are you only talking about affecting the current one that's in place?
Yeah, no, this would be an enhancement. It should be an enhancement. That's the intent of the bill, is to add to what is already in the bill.
Indictment, the second felony, or just flipping up the one that's already there? That's my question.
Well, yes, pumping up the one that's already there.
Which, Mr. Chairman, if I may, back on the amendment, that's the point of the question I was making. If it's an enhancement, which it looks like it is, then Senator Simmons' amendment, correct, you're basically making it the same penalty as what is already there.
No, if it's an enhancement, it's an additional crime. So my point, Senator Chairman Wiggins, is you could be charged 0 to 5 years on the current crime, but then you also can get an additional consecutive 0 to 5 years on the felony fleeing.
That's not what Senator needs to say.
But that's the way Senator Sparks and I. That's what, if we wrong, please tell us, because that's the purpose of my amendment.
Sorry, Mr. Chairman. I think the problem is the definition of enhancement. So some define enhancement as, so for example, on a drug case, if you commit a crime, possession or a transfer within 1,500 feet of a school, then that's an enhancement. So not only so if it's a 3-year penalty, you actually it's enhanced to an additional 2 years or whatever it may be. It's one crime. You cannot indict them for 2 separate crimes. But some people do argue about enhancement that ends up being 2 separate crimes. And that's, I think, what Senator Simmons is getting at. But from what I've heard from Senator England is this is simply an enhancement because, first of all, the only way you get to Section 6, line 45, is you have to have committed subsection 2, which is manifest an extreme indifference to the human life. If you actually look at DUI, there's the misdemeanor DUI, and then there's a felony DUI if you're causing injury, which is a felony in and of itself. If you cause injury during a DUI, that in and of itself is a felony, even if you were at the level of a misdemeanor. And that's what I think this is trying to do, not create a separate charge to indict. Is that, Senator?
Clarify what your bill does.
Right. Thank you, Mr. Chairman. And if I may make a motion, if Senator Simmons would agree to withdraw his amendment at the time, I would like to make a motion to lay this on the table, subject to call the chair.
I agree with that, Mr. Chairman.
Recommendation to lay the bill on the table. It's only reserved until we talk about it later.
Correct.
Again, we're willing. All right, you've heard the motion. All in favor, say aye.
Aye.
Opposed, nay. The ayes have it. Are gonna continue to rise and report.
Rise and report.
All right. All right, good for your bill. You're up next.
You're good. I'll be prepared now.
All right, so I'll put a lot of work for you.
Yeah, I'm sure they're right. I think they were just.
Yeah.